Welcome viewers to Kanooni Charcha. You might have noted, viewers, that in cases under negotiable of instrument act, check dishonor case, ordinary, you are knowing, a complaint is filed before a magistrate under section 138 of this act, negotiable of instrument act, that there is a procedure of issuance of a notice first, demand notice, and within a particular period one has to file the complaint under 138. Now, I will now confine my today's episode, which is I will also discuss the recent Supreme Court of India's judgment here. Firstly, I will narrate some. I will tell what how the matter in the courts of law is being proceeded and dealt with, how the complainant and how the accused reacts when there is a complaint filed. Generally speaking, when a complaint is filed, an effort is made by the magistrate. It is also as per the direction of the many judgments, Supreme Court of India and various high courts have directed that magistrate should make an effort, his endeavors to have a resolution of the, because it is considered earlier a civil wrong, but now it is a proceedings held under 138 or negotiable instrument act is referred as, is considered as the quasi criminal proceedings. Now, question is, sometimes the compromise is that the complainant is ready to have compromise and gets the payment, but afterwards refuses to take back the complaint. Sometimes situation may rise that there is a delay in making of payment by the accused. The court which allows the compromise sometimes gives the time for repayment by way of installment, and time is also given of certain months, days, you may say. If there is a delay and both the parties, or particularly complainant, after taking back, I will refer few cases, and I have, as a magistrate, when I was in service and as an advocate, I have seen that complainant, after getting money, becomes reluctant to take back his complaint, and accused insists that let the complaint be disposed of, be dismissed. But how it can be dismissed? Section 147 no doubt provides that the offence is compoundable. Or many judgments of the Supreme Court, various high courts, are that compromise can be arrived between the parties at any time, at trial stage, at appellate stage, or sometimes even in Supreme Court, High Court, where the proceedings are pending. Sometimes conviction is made of the accused and he is sentenced and he is in jail. Then his relatives makes arrangement, his well-wishers made arrangement for payment of money to the complainant and tries to have compromise. then in many cases complainant takes money but did not agree to take back the complaint, take back the he is not ready. In many Supreme Court judgments and High Court judgment, you will find that earlier many judgments were there of the Honorable High Court as well as Supreme Court of India, that there is no need of complainant to have his consent if he is satisfied the amount of check amount and whatsoever the trial court has done made with regard to interest component as well as the if the check amount along with interest and all in ancillary liability have been discharged by the accused, then the complaint must be dismissed. But this practice adopted by the trial court and in some matters by the High Court and in some matters Supreme Court earlier made have their decision that it should be dismissed because this complaints under section 138 under negotiable instrument should be considered as a this civil wrong. But the statutes this obviously if we touch section 320 of this code of criminal procedure, now there is a Bharatiya Nagrik Suraksha Sanhita, a corresponding section which provides how the compromise to be made. Obviously compromise, it is not a it is settled law that compromise cannot be without the consent of the complainant. There is I making this my overview about the topic which I have chosen today. I now touch a judgment of Supreme Court of India, very important judgment. Reddy one more judgment I will refer later on. First, I will touch this judgment. What happened in this case? In short, I will tell that complaint was filed by the complainant under section 138A of Negotiable Instrument Act. Accused was convicted. Appeal was filed. In the appellate stage, when appeal was pending, the matter was taken to this before the Lok Adalat. In the Lok Adalat, some agreement was right. What period provided for repayment was, according to accused, was not sufficient. He could not make the repayment. Accordingly, the complainant becomes reluctant. However, after the matter anyhow comes to the Supreme Court of India, now which I have to deal here, I have to delve upon this judgment. What was there? The question arises: by the complaint can be withdrawn, can be dismissed by the trial court, or High Court can quash the proceedings. This I am referring. I will deal with by referring another judgment here. Now this is a question before which we are supposed to discuss, which I am supposed to discuss. I will directly go to the relevant paras. I think para 11 of this judgment. This is a judgment I am going to discuss. This Reddy versus State of Haryana on 8th of April 2024. Supreme Court of India have decided this case. Para 11. As per the section 147 of Negotiable of Instrument Act, all offences punishable under the Negotiable Instrument Act are compoundable, which I have referred verbally. However, unlike Section 320 of CrPC, N I Act does not elaborate the manner in which the offences should be compounded. I have already referred that detail how and who has to file application, what is procedure process involved while this composition of the offences to fill in the case at hand. This case of Reddy Kilam. Initially, both sides agreed to compound. I have referred verbally earlier that a compromise arrived in the Lok Adalat when appeal was pending against the conviction of the conviction of the accused here. At the appellate stage, but appellant could not pay the amount within the time stipulated in the agreement, but I have verbally already told like you. Thereafter, the money was paid whatsoever is to be. But now, in this case, Article 142 was invoked by the Honorable Supreme Court of India. The Supreme Court of India is a apex court, and it, as a constitution of India has provided, has given, empowered the Supreme Court of India to do complete justice by invoking 142. Anything can be done. Now, even though now para 14 is relevant for this crux of judgment, you may say, of this, and crux of the matter where the complainant is not ready. The settled law is the trial court. No court statutory provisions are to be followed. Compromise is only with the consent of the complainant. No complainant. No court, trial court cannot dismiss that its own. Even now, I will refer one more judgment where the High Court invoked its jurisdiction under Section 482 of Code of Criminal Procedure. The Honorable Supreme Court has held in S Pharma Private Limited versus Nayati Medical Pvt Limited that High Court has no inherent power to override the provisions of Section 147 of Negotiable Instrument Act. The High Court cannot exercise its inherent jurisdiction, you may say, under Code of Criminal Procedure in such a matter. Though the statutory provisions are to be the whatsoever is available in 147. I will now come to that also. This is now, even though complainant is unwilling to compound the case, but considering the totality of the fact. This is in this case of Reddy Kilam, which I am dealing. But considering the totality of the facts and circumstances present case, which we have referred above, we are of the considered that these proceedings must come to an end because the whole amount has been paid. We therefore allow this appeal and set aside the impugned order of High Court dated 29th of November 2020. We also quash all the criminal proceedings for appellant arising out of FIR number itne Ambala pending before Chief Judicial Magistrate Ambala. Since criminal appeal filed by present appellant against his conviction under Section 138 of Negotiable Instrument Act are also pending, we deem it appropriate that said proceeding should also be quashed. One FIR was also pending. The Honorable Supreme Court of India invoked its jurisdiction and ordered quashment of that FIR also. Hence, in order to do complete justice, we exercise our power under 142 of the Constitution of India. This power is only vested with the Supreme Court of India. for doing complete justice. This such type of powers cannot be invoked by Honorable High Court also, the High Court, and hereby quash all the pending criminal appeals on file of addition session judge where the Lok Adalat Ambala can against the appellant in the present matter and set aside the conviction and sentence awarded to the appellant by the trial court. We work on the conviction and the sentence for that was also passed. Why? But why invoking one? Or two? Not otherwise. We also direct the trial court to hand over the demand draft totaling amount 30 lakhs to a complainant, which were deposited in the trial court in pursuance of this court's order, if any, handed over till now, pending application disposal. It was to bench Justice and A.S. Bopana and Justice Sandashu Dulia were the judges on the bench who have delivered this judgment. And but in another judgment of Supreme Court of India, which I have referred, S Pharma Private Limited versus Nayati Medical Pvt Limited, it is a dated the similar power 140A Article 142 of Constitution of India was invoked and invoked for allowing the parties to compound virtually and not allowing the new parties to compound, but the Supreme Court of India at its own for doing complete justice by invoking Article 142 dismiss the complaint and you can say quash the whatsoever proceeding was before the trial court. When the complainant was not interested to compound the matter. The law is settled now. I'll make a crux here of summarize the matter. That law is that without complainant, no compromise can be arrived with regard to a complaint under Section 138 of Negotiable of Instrument Act. No trial court, high courts, in this case S Pharma versus Private Limited, Nayati Supreme Court of India has held that High Court cannot invoke its inherent power under Section 482 of Code of Criminal Procedure for quashing the proceedings, even which may result into dismissal of in this judgment, I have referred as Pharma. The High Court is not vested with such a jurisdiction. Only Supreme Court of India under Article 142 for doing complete justice can make such an order, which they have made in AS Pharma Private Limited versus Nayati Medical Pvt Limited, and in this judgment which I have today delve upon. Now it can be. We have discussed two judgments: Reddy for the state of Haryana. Matter is that crux of these two judgments is that no compromise without consent of the complainant, no quashment by the High Court, which may result into composition without the consent of the complainant for a complaint under section, in a complaint under Section 138 of Negotiable of Instrument Act. What Supreme Court of India can invoke its exclusive superior jurisdiction, constitutional jurisdiction for quashing the proceedings in the interest of justice, for doing complete justice in specific and particular case. not as a matter of course in a routine. In specific case where the Honorable Supreme Court of India finds that this is a fit case where the Article 142 of Constitution of India are required to be invoked. Now, in nutshell, I have taken much time, but elaboration is required. I have found this judgment in the Supreme Court of India's website, and accordingly, I have discussed, and I think it is sufficient for today. Thank you very much.